Okay, it's 4 minutes past the hour. I think we will crack on, even though people will still be coming in. Hello, wherever you are in the world, and welcome to this solicitation conference on the request for proposals for the International Registry for Mac equipment. Greetings from Rome, the lovely room you see behind me, and behind Professor Veneziano's is the map room in the Untitled building. So it's part of the institution which hosts the Mac Protocol and the Cape Town Convention, which is Untitled, an almost 100 years old intergovernmental organization. I'm explaining this for those of you who are not familiar with the Cape Town system yet. Excuse me. Back in November 2019, hosted by the government of South Africa, a diplomatic conference took place to approve what would be the fourth protocol to the Cape Town Convention on International Interest in Mobile Equipment, this time concerning mining, agriculture, and construction equipment. That same diplomatic conference, in a resolution, determined the establishment of a preparatory commission, which would create and prepare the infrastructure, both legal and institutional, to be able to implement the new protocol to the Cape Town Convention. It is in this context that considerable amount of work for many months was conducted, both by this secretariat of UNISRA and a group of observers and experts included in a subgroup on the registry, which availed itself of the work of procurement and technical experts from different countries in the world to come up with a request for proposals. This request for proposals was approved finally by the Preparatory Commission and issued recently on the 21st of March of 2022. So it is in this context that we are holding this solicitation conference. We are hopeful that in line with best procurement practices internationally, we're hoping that this conference will help disseminate the RFP and clarify if there are any doubts its content. We deem this conference as an important element to ensure transparency in the process, and we are very hopeful that it will be useful to all of you, and that soon we will be receiving many high-quality tenders for the registry of what promises to be an incredibly exciting project and very, very important instrument in international commercial law. Thank you for being here, and without any further waste of time from my side, I will hand over the floor to Hamza. Hamza.
Thank you very much, Ignacio, for that kind introduction, and welcome to all of the participants who should now be able to see my screen. As the Secretary General noted, this is the solicitation conference for the requests for proposals for the International Registry for Mac equipment. In this case, MAC stands for the Mining, Agriculture, and Construction Protocol of the Cape Town Convention, which my Deputy Secretary General will talk about shortly. Before we move into the actual presentation, I would just quickly outline the program of the event, which is such that we will have an opening of the session, which we just had by our Secretary General. We will have an introduction to the MAC protocol by our Deputy Secretary General, Professor Anna Veneziano. And then I will talk about the request for proposals for about 35 to 40 minutes, with at least 20 to 25 minutes being available for question and answers with the attendees of this session. We invite all of the participants to please ask questions at any point in time of the presentation using the Q&A feature. Depending on your settings, this will either be at the bottom of your screen or at the top of your screen. You may even use the chat feature. We will be monitoring that, but please don't use the raise hand feature, as that's not an option in this webinar. The Secretariat will only seek to answer questions of an administrative nature, as none of us are technical experts in this area. All technical questions will be answered as part of the clarifications process of this RFP. And if you do ask a question that is a technical question as part of this event, we will note that down and forward it to the clarifications process automatically, and it will be answered on the 21st of June as part of the set of clarifications that will be released. For any additional questions, concerns, queries, you are always welcome to write an email to macrfp@unidwa.org. And with that, I will now hand the floor to my Deputy Secretary General, Professor Anna Veneziano, for an introduction of the MAC protocol. Thank you.
Thank you, Hamza, and greetings to all of you. I promise that this will be a very short and brief introduction. It's for the purpose of introducing the Cape Town Convention system and the MAC protocol within that system, for those of you who know less about the system. So the Cape Town Convention is a treaty system introducing a uniform legal regime to facilitate asset-based financing, including leasing, for the acquisition and use of specific types of high-value, mobile, and uniquely identifiable pieces of equipment in strategic industry sectors. And this, as you see, there is a two-tier structure. There is an umbrella convention, the Cape Town Convention, being supplemented by individual protocols which apply to specific industries. And of course, the convention will apply only in conjunction with one of the protocols. So there is a protocol on matters specific to aircraft equipment already in force since 2006, the Luxembourg Rail Protocol for the financing of in the rail industry, which is on the brink of entering into force. And then we also have the Space Protocol on matters specific to space assets. And the last baby, if we can call the protocol like this, is the Mining, Agricultural and Construction Equipment Protocol, adopted in 2019 at a diplomatic conference in Pretoria, if I may say, just on time. This is just to show the political acceptance of the Cape Town Convention, especially through its aircraft protocol, which has been incredible. Now standing to 83 contracting states and approval by the European Union. And you can see from the blue, of course, are the contracting states. But I think it's probably more interesting for you to go to the next slide and to look at what are the main objectives of the Cape Town Convention and its protocols, and including, of course, the MAC protocol. As I have already said, it aims at facilitating the acquisition and financing of economically important items of mobile equipment, and it does so by creating an international interest deriving from a security agreement or a retention of title agreement or a leasing agreement, and the rights of the creditors will be recognized in all contracting states, which is not possible without this uniform legal regime. It provides the creditor with a range of basic, default, and insolvency-related remedies, and also means of obtaining speedy relief pending final determination of the claims of the merit. When there is a court proceedings, there is also the possibility to use extrajudicial enforcement remedies. But the center of it all, and this is particularly relevant, of course, today, is the electronic international registry. And there is a separate electronic registry for each protocol, and it's for the registration of international interest. The registry, as will be noted also later on, will give notice of the existence of the international interest to third parties, and will particularly enable the creditor to preserve its priority against subsequently registered interest, unregistered interest, and creditors in the debtor's insolvency with very limited and well-defined exceptions. So we have already seen that the main convention accompanied by the protocol, because the protocols meet the particular needs of the industry sector, and this is true also for the Mac protocol, which has follows the basic structure of the preceding protocols, but has special rules and provisions for the Mac sector. The Cape Town Convention and its protocols also provide states with a degree of flexibility in making policy choices through declarations by preserving, however, the basic uniformity of the legal regime. So all this legal architecture has the aim to give intending creditors greater confidence in the decision to grant the financing, to enhance the credit rating of equipment receivables, and to reduce borrowing costs and credit insurance premiums to the advantage of all interested parties. And now this is not just words. We have the example, of course, of the practical application of the aircraft protocol, but in particular for the Mac protocol, an independent report prepared by Warwick Economics and Associates, which was published in 2018, shows the expected economic benefits for the Mac protocol, which are indeed enormous for countries that ratify. Here you see the staggering numbers, a positive impact of $23 billion on the GDP in developing countries and $7 billion in developed countries. The total impact is $30 billion a year. There is also an estimate on the increase of the stock of Mac equipment, which is extremely important, especially for developing countries, and it will increase by $90 billion. And again, this report is actually conservative in its results because it only covers UNIDROIT's 63 member states, but the Mac protocol is expected to apply, of course, all around the globe. So I think I have finished with this brief introduction. Of course, if you have any questions, we are very happy to be able to answer them, and I will immediately give the floor to my colleague, Hamza Hamid.
Thank you very much, Anna, for kindly introducing the Mac protocol. As Anna noted, the third of those 6 objectives and goals pointed out in the main purposes of the Cape Town Convention is indeed the establishment of an international registry that gives notice of the rights, international interests held by parties within different pieces of equipment. And that's the context in which that we're organizing the solicitation conference and conducting this procurement activity in general. So as was noted by my Secretary General at the beginning, this request for proposals for the International Registry for Mac equipment was published on 21 March 2022 on behalf of the Preparatory Commission for the Mac Protocol. For those who are not aware of what the Preparatory Commission is, the Preparatory Commission, as mentioned, was established pursuant to Resolution 1 of the Mac Protocol Diplomatic Conference and was given the authority to act as provisional supervisory authority for the Mac Protocol until it enters into force. We'll talk a little more about what a provisional supervisory authority is later on in this conference, but generally, the Preparatory Commission, which operates under the guidance of the UNIDROIT Governing Council and the General Assembly of UNIDROIT, has 3 key responsibilities. The first one being the selection of a registrar to operate the Mac Protocol International Registry, which is the responsibility in the context of which we're organizing this activity and have launched the RFP. The establishment and or appointment of a supervisory authority, and C, the preparation of the first edition of the International Registry Regulations, which is also an activity very relevant to this exercise and will be talked about later on in the session. The Mac Preparatory Commission is a sovereign body that has 16 member states, as well as several observers. These member states come from various different parts of the world and include signatories of the Mac Protocol, as well as countries that have been closely involved with the negotiation and development of the Mac Protocol, the Cape Town Convention, and have generally showed their interest in the treaty. Moving now to the request for proposals itself, the RFP is a very all-inclusive and comprehensive document, which is broken down into 5 parts, 6 annexes, and 1 appendix, which consists of 9 forms. We will be going through all of these in the next 35 to 40 minutes, and we would greatly welcome any questions that the participants have on any of them. Part 1 is an introduction. Part 2 is the technical requirements. And then important to note here, Part 2 is supplemented quite extensively by Annex 3, which is the statement of requirements. Part 3 is a cost specification section. Part 4 relates to information about key contract provisions. Part 5 relates to the practical information about the solicitation process, which we will be detailing a bit more later on in this session. Annexes 1 and 2 relate to the additional relevant background information about an international registry and the relevant provisions of the Cape Town Convention and the MAC Protocol that relate to the international registry. As I said, Part 3 is a statement of Annex 3 is a statement of requirements. Annex 4 is an illustrative model of a layout for an international registration form. Annex 5 contains the MAC registry regulations. Annex 6 contains a guide on best practices to be followed in the design and operation of an electronic collateral registry. And Appendix A contains all the relevant submission forms for this RFP. Moving now to Part 1 of the RFP. Part 1 of the RFP is further broken down into 4 sections. The first section is an overview of the document itself. This contains a lot of the background and details of the task and the basic description of the registry. The purpose of this RFP is to invite interested parties and entities to submit a request to participate in the solicitation for being awarded the contract as the registrar for the International Registry for MAC equipment. The function of this registrar will include, among other things, being responsible for the design, production, delivery, installation, and ongoing operation and development of the international registry. And this international registry will be an electronic and internet-based registry, which will be accessible via a dedicated front-end interface, including a website, and all user transactions, including registrations and searches, will be undertaken electronically through the front-end interface. We'll talk more about the interface and the design of the registry as part of Part 2 on technical requirements. It's important to mention that in relation to the registration and search services provided under the MAC protocol, the supervisory authority will be the one working in close consultation with the registrar to be setting the fees and periodically reviewing the fees that the MAC International Registry will charge. These fees will include operating costs of the registry, the costs of setup, transaction volumes, as well as the reasonable costs of the depository. Section 2 of Part 1 clarifies what the Preparatory Commission is looking for in conducting this procurement exercise. Firstly, Part 2 provides a description of the nature of the parties and the participating entities. In this regard, it's important to point out that a request to participate may be made either by a public or a private entity. We expect that the entities that will be participating will have arrangements and engagements with some subcontractors and service providers for the delivery of certain parts of the registry. And we expect details of these as part of the solicitation package. This section also describes the basic items that are being desired. For this, I would point to paragraph 13 of the RFP, which details that the requests to participate shall include an offer to be evaluated by the Preparatory Commission, having regard the following factors: Number one being the tenderer having sufficient relevant business and management experience to successfully establish and operate the international registry. Number two being the proposed corporate structure and ownership structure of the registrar. Number three being the extent to which the offer complies with the technical requirements in Part 2 of this RFP and the statement of requirements in Annex 3 of this RFP. Part 4 being the offer's compliance with the key contract provisions that are found in Part 4 of the RFP, and Part 5 being the cost elements in the offer, which can be found in Part 3 of the RFP. This, of course, is a basic definition of the types of information which is required, but again, is extensively detailed when the RFP moves on to describing the practical elements of how bidders must submit their application. As noted earlier, a request to participate must provide all the details of the proposed corporate structure of the registrar. However, it is not necessary that a request to participate and offer be submitted by the same corporate entity that would act as the registrar, as long as that entity commits to be bound by the request and the offer. This part of the RFP also describes the role of the supervisory authority and that of the preparatory commission, which includes an explanation of the role of the supervisory authority and its relationship with the registrar, and an explanation of the role of the preparatory commission and its relationship with the registrar. Article 17.1 of the Cape Town Convention provides for the establishment of a supervisory authority as provided by any protocol of the Cape Town Convention. So, for example, under the aircraft protocol of the Cape Town Convention, which was talked about earlier, the supervisory authority is the International Civil Aviation Organization, or ICAO, whereas for the Luxembourg Rail Protocol of the Cape Town Convention, the supervisory authority is an intergovernmental organization for the transport of rail, called OTIF. And similarly, we are presently working on identifying and appointing a supervisory authority for the Mining, Agriculture, and Construction Protocol as well. Resolution 2 of the Diplomatic Conference details the process of establishment of the supervisory authority or appointment of the supervisory authority. And this is one of the key agenda items of the work of the Mac Preparatory Commission right now. According to Article 17.2 of the Convention, two of the main activities of the supervisory authority include establishing or providing for the establishment of the international registry, as well as appointing and dismissing the registrar. As noted earlier, Resolution 1 of the MAC Protocol Diplomatic Conference put the Preparatory Commission in the position of a provisional supervisory authority for the MAC Protocol, with a view towards guaranteeing the operability of the international registry by the time that the protocol enters into force, and to ensure that the registrar managing the international registry is selected in accordance with an objective, transparent, and fair selection process, and that all the necessary regulations and procedures have been prepared and approved. In this regard, it was the Preparatory Commission that worked on the development of the RFP document under a specialized group. This specialized group comprised of various governments from different parts of the world and included several procurement experts in the field of IT, software development, system design, and others that provided a lot of feedback to the development of this RFP to make sure that it met all of the requirements necessary. I'm being told in the chat that the PowerPoint might not be moving. Let me try to move the slides and see, is it working now?
Yes, it is working. Can you scroll down further? Yeah, it is moving.
Okay,
Yes.
so I think I'm just taking a bit too long on this slide, so I'll try to move a little faster. Yes, as noted, the Preparatory Commission will be acting as provisional supervisory authority. And so in the RFP document itself, unless the context indicates otherwise, any reference to the Preparatory Commission is always a reference to the Preparatory Commission acting in its capacity as the provisional supervisory authority. Additionally, okay, and then the last section of part 1 relates to promotion and industry support. Of course, the registrar will play a key role in promoting and further in moving the MAC protocol towards entry into force and in its further development. And as such, the RFP envisages that any registrar that will be appointed should allocate at least 35,000 euros per year towards the promotion activities of the MAC protocol, which would include attendance of seminars and meetings. Part 2 of the RFP relates to technical requirements. Before I delve into this, I would very explicitly note that I am not a technical expert, and a lot of guidance on these technical requirements was provided by the technical experts in the specialized group that I mentioned earlier. So I will be describing many of these technical requirements, but as noted, all of the questions and concerns with regard to them will be passed on directly to those that have this expertise, and then will be answered in the clarifications process. Part 2 is divided into 3 sections. Section 1 being a section on general technical requirements, which is further subdivided into 27 general technical requirements. The general overview describes that the technical requirements section is supplemented by the statement of requirements as outlined in Annex 3 of the RFP. The request to participate must include, among other things, all details of providers of the software services, and support services, as well as all of the items listed in Part 2 of the RFP and Annex 3 of the RFP. In order for the bidders to have an understanding of the types of services that they are expected to offer, paragraph 29 of the RFP provides several indicative numbers and figures with regard to the activity of the registry under the aircraft protocol of the Cape Town Convention. So this provides the volume of transactions being processed by the aircraft protocol registry, and may be looked at as a purely indicative example by bidders that are looking to submit a bid to this procurement. It is important to note that these are purely indicative amounts, and bidders are actively encouraged to do their own research and develop their own assumptions with regard to how active the MAC protocol registry might be, and that the MAC protocol registry could have significantly larger or significantly smaller volumes compared to that of the aircraft protocol registry. This section then moves on to a description of what the registry will be. This details that the registry will be an electronic internet-based registry, and that apart from the process of authorizing registered users, all registry transactions and services will be automated and able to be provided without direct real-time human intervention on part of the registrar. At this point, I would note that the domain for the website shall be owned by the supervisory authority and used by the International Registry under a license for the period of the registrar's contract. This section also specifies that the design of the International Registry should be compatible with application program interfaces, or APIs, so that users can interact with it and use it in various different ways. It also specifies that the website must have a responsive design that's capable of being viewed on various different types of devices with different screen resolutions and sizes, and then should also generally be workable with mobile browsers and internet browsers, a list of which is provided in paragraph 32. This section then moves on to describing parts of the RFP, which are very closely linked to the regulations. So any registry, of course, has a close relationship with the regulations that describe and exemplify its operations. So the registry regulations provide very clear processes for authorization of registered users, and the registry that will be developed by bidders to this RFP will be required to recognize what those processes are in the regulations and then build a registry that is in compliance with those regulations. These can be found in Annex 6 of the RFP. Part 4 talks about how the registrar will be required to make an attempt to minimize the risk of unauthorized registrations and or incomplete registrations. In this regard, details can also be found in the regulations, but the system will need to be designed so as to minimize the risk of unauthorized registrations as indicated in the resolutions, and preventing registrations which do not contain the information required to effect a registration of any nature. As noted by my Deputy Secretary General, the purpose of this registry is to inform the world of interests in assets, and as such, the International Registry will need to be designed to enable a minimum of information to be entered in order for interests to be registered and searched for, as registrations in the registry will be indexed in relation to an identifier of Mac equipment rather than the identity of the parties or any other criteria. The registration of the international interest will contain minimal information as detailed in the regulations, including, of course, an electronic signature of the registering person, the name of the named parties, and information identifying the Mac equipment. Pursuant to Article 18.1a of the Cape Town Convention, and then this is the next section, which talks about unique identification criteria for registrations. The Cape Town Convention, one of the key elements of the Cape Town Convention is that all assets subject to interests under the Cape Town Convention must be uniquely identifiable. This is specified in Article 18.1a of the Convention, and then further detailed in Article 27 of the Mac Protocol, which says that the specific criteria for how uniquely identifiable Mac equipment will be defined shall be set out in the regulations. The Mac Preparatory Commission, with the support of another specialized body, has already developed the first draft of the regulations as noted, which is found in Annex 6 of the RFP. This goes on to detail what the unique identification criteria will be. And this takes a two-prong approach. This is found in Article 5.1b of the regulation, and says that the following information shall identify a piece of Mac equipment. A, the object's ISO compliant number. If it has one, this shall be enough to uniquely identify the piece of Mac equipment. Or B, if the object does not have an ISO compliant number, then the alphanumeric serial number that is assigned to the object by the manufacturer. In the case that an object does not have an ISO compliant number, as referred to above, the registrar shall also collect items such as the brand name for the equipment, if unavailable, the name of the manufacturer, the manufacturer's generic model designation for that object, and one other item of descriptive information about the equipment, as so determined by the procedures of the International Registry. It's important to note here that these are items that are still under discussion and might evolve as the regulations of the International Registry continue to develop. Parts 7 to 11 of the general technical requirements describe the various different types of interests that can be registered within the International Registry, including registrable non-consensual rights or interests, notices of sale, assignments, and block assignments, details of all of which can be found in the regulations. Part 12 notes that the registry will also contain information about contracting states to the Cape Town Convention and the MAC Protocol. In particular, this will include information about the instruments of ratification or accession of contracting states and the declarations made by contracting states. This information should be added and should be searchable according to each particular contracting state. Part 13 of the general technical requirements talks about relates to Article 29.1 of the Cape Town Convention and Article 18.4 of the Convention, which puts a significant amount of importance on the round-the-clock operation of the registry, as well as the accurate recording of time of registration activities. According to Article 18.4 of the Convention, the registrar must ensure that registrations are entered into the International Registry database and made searchable in chronological order of receipt, and precise timing information must be recorded and must be contained in all registrations and searches. The timing at which information is entered and made available to those who conduct searches is critical to the convention system of priorities, and any bidder participating in this RFP, in this procurement, must recognize this and must provide a description of how this registry will work accordingly. Part 14 reinstates that this is a notice-based system. That is, it will provide notice that an interest has been registered in relation to a specific MAC asset. The registrar will not confirm the accuracy of information provided by registered users, and will also not confirm the existence or validity of documents underlying a registration. Additional details on all of these are available in the regulations. Part 15 talks about the integrity of the registration process. As noted, the registrar will not be involved in reviewing the validity or accuracy of information prior to it being posted on the International Registry, and the process of registering an international interest will be automated. The MAC protocol also has a provision for entry points, and this is reflected in Part 16 of Part 2 and is in line with Article 16 of the MAC protocol and further described in Section 13 of the regulations. So in the case that there is a direct transmission of information between the registry and an entry point, as set up or communicated by a contracting state of the MAC protocol, the registry should be able to record those entries and then should be able to communicate with the entry point accordingly. A contracting state that designates an entry point obviously has to inform the depository, which is UNIDWA, and the supervisory authority thereof. And the supervisory authority shall always keep the registrar informed of any such designations of entry points so that they can work with each other. Part 17 talks about languages. It describes that the International Registry will be required to operate in English. Additionally, 17A notes that the International Registry will be required to provide help desk related services in front-end interface in Arabic, Chinese, English, French, Russian, and Spanish from its entry into operation, and that the fields requesting information from users should also be available in all of the aforementioned languages. The contract between the registrar and the supervisory authority will also provide for the inclusion of an additional language, and in the time frame for that language will be specified. Very importantly, the International Registry will accept registrations in any language that the users may wish to provide information in, including the use of diacritical marks. This section also describes the details of the frequently asked questions section of the registry, the technical support, and the help desk that the International Registry will need to enable. This will need to, the live help desk assistance will need to be provided for at least 40 hours per week, and details of this can be found in paragraph 60. As noted earlier, the international registry must be scalable. The bid must provide details of the software applied and must also contain details on the software upgrades and enhancements, such as security fixes and bug fixes that will be needed from time to time. Part 22 talks about system availability, which is expected to be 99% per year. The 1% left out is envisaged for things such as maintenance, power outages, etc. Part 23 talks about system integrity. 24 talks about contingency and data recovery plans. And the rest of this section talks about capacity for permanent storage of records, domain names, and the location of the registry. As noted earlier, in terms of domain names, logos, etc., the ownership will be by the supervisory authority, and a license will be provided to the registrar. Part B and C of Part 2 talk about the technical functions and specifications of the registry and the system requirements. These are fairly self-explanatory, and going through them will take a significant amount of time, so I will not do that. But if the bidders have any questions, then they're definitely invited to submit to the clarifications process. Of particular importance is the system design document referenced in the part on technical functions and specifications, which is a compulsory document that will need to be submitted within 90 days of the finalization of the contract between the registrar and the supervisory authority. And all details of this document are detailed in the RFP. The system requirements part details all of the very technical details of the registry. And this is supplemented extensively by the statement of requirements found in Annex 3 of the RFP. Moving on to Part 3 of the document, this relates to cost specifications. Generally, each request to participate must include a comprehensive schedule of estimated costs in euros for the fulfillment of the obligation of the registrar, including the establishment and ongoing operation of the registry. All of these prices should be valid as of 21 March 2022. The assumptions used to define some of these costs should also be clearly laid out. Paragraph 104 contains a list of all of the startup costs and costs of establishment that any registrar must consider in providing these cost estimates. And paragraph 105 contains a list of all of the annually recurring charges, such as personnel, rent, wages, software and hardware replacement, that all registrars must consider when filling out the details with regard to this section. It's important to note here that all of this section needs to be filled out using Form 9, which is an Excel spreadsheet, which is provided separately. Cost estimates are required so that the supervisory authority may be able to work towards developing the fee structure for the international registry, keeping in mind that the cost of Mac equipment, which will be subject to registrations, is not as high compared to other sectors, such as aviation equipment. It is expected that the registrar to ensure that the costs relating to filing registrations in the registry are kept as low as possible. I would note that the registrar would be in a position to provide ancillary services. What ancillary services are and the context in which they will be provided can be found in paragraphs 108 to 111 of the RFP. This includes examples of the types of services that will be provided. Revenue generated from ancillary services is divided into two categories. The first one, which are ancillary activities that relate directly to the main activity of the registrar, which is managing the international registry. For such services, at least 40% of the gross revenues, unless otherwise agreed, will be required to be allocated towards the payment of the establishment costs of the registry. The second category would encompass services that the registrar can provide independently of its role of being the registrar of the Mac Protocol International Registry. For this, the supervisory authority and the registrar may agree amongst themselves of how the revenues and profits shall be allocated. I've already clearly noted the relationship between costs and fees, but as noted, keeping in mind the lower value of Mac equipment compared to some others in the Cape Town Convention system, it is expected that the costs of filing a registration will be kept low. These fees will be determined in close consultation between the supervisory authority and the registrar, but the ultimate decision will be made by the supervisory authority. Part 4 of the RFP will probably take the least amount of time to go through. This is information about the key contract provisions. This has to be filled out using Form 5, which is a contracts matrix. And there are 8 mandatory provisions which relate to things including the requirement to operate the registry in compliance with the regulations, things such as proprietary rights, the termination clause of the contract, the beneficial ownership of the registrar, liability and insurance, as well as parties to the contract, and 5 non-mandatory provisions, including items such as performance guarantees, the law of the contract, and in the test phase. I understand that only 4 of them are listed on this slide. That's an error from my side, and you can look at the RFP to find the 5th one. I would note that all mandatory provisions must be agreed to by the registrar, and the Preparatory Commission will not showcase any flexibility in those, whereas non-mandatory provisions may be subject to discussion. Next is probably one of the most important sections of the RFP. This relates to practical information about the solicitation process. This is subdivided into 6 sections, the first one being the content and format, the second one being details on supplementary information, the third one being the practical information related to the actual submission process, the 4th being the evaluation and selection process, the 6th being illustrative timeframes, and this last one, and the 6th one being communication. With regard to the content and format, this is fairly self-explanatory and can be found on page 29 of the RFP. All submissions must be clear, comprehensive, and self-contained. The Preparatory Commission completely reserves the right to come back to bidders asking for clarifications should it need to, and will do so where necessary. Where the tenderer is requested to present a requirement with a specific approach, the tenderer must not only state its acceptance, but also describe, where appropriate, how it intends to comply. In the case where a descriptive response is required, failure to provide the same will be viewed as non-responsive. The deferral of requirements and responses to the contract phase is also not acceptable. It's important to note here that all information submitted should be valid for the next 270 calendar days after the deadline for the submission of the request for proposals. With regard to supplementary information, the Preparatory Commission reserves the right to issue addendums to the document, although none are envisaged at this stage. At the same time, the bidders may request clarifications by the 21st of May. Using the email address noted here, all clarifications will be released on the 21st of June, 2022. With regard to the actual submission process, the submission process consists of 2 separate categories. Category 1 being the cover letter, and category 2 being the forms 1 to 9, as clearly specified. The cover letter must be dated and signed by the tenderer or any other duly appointed representative, declaring acceptance to the conditions of the RFP and in its unconditional request to participate in the tender process. The forms listed should all be submitted in preferably in Adobe PDF 9.0 or later, but would also be accepted in Word format. We request bidders to submit all forms as separate files. This is because of the way the evaluation process is structured. And then we request that the overall size of the email should not exceed 10 megabytes. The Secretariat will acknowledge the receipt of all emails to the email address listed on this slide. At this stage, I would kindly note that there is a tiny mistake on page 31 of the RFP in part B9, where it suggests that one of the sheets in Form 9 is optional. this is not the case, and all 3 sheets in Form 9 are mandatory. Even though the 3rd sheet is will not be subject to evaluation and is purely indicative. Next, I will talk about the evaluation and selection process of the RFP. This is divided into 4 phases. The first phase is the Preparatory Commission will conduct the evaluation with the support of experts that will be appointed to an evaluation committee. This evaluation committee will be balanced and from a broad geographical distribution. Phase 1 of this evaluation relates to an initial screening through general forms. These general forms are, this is one general form found in Form 2 of Appendix A and relates to a pass-fail test. What the requirements for this pass-fail test are found in paragraph 147 of the RFP. The eligibility criteria are designed to ensure that to the degree possible in the initial phase of the RFP process, only those tenderers that can demonstrate a sufficient capability to actually fulfill the tasks set out by the RFP will be considered. Only tenderers for whom this capability can be proven by factors such as, but not limited to, showing economic and financial stability, demonstrable technical knowledge and or superior customer references, qualify for further consideration. Additionally, tenderers must also demonstrate that the registry will be situated in a jurisdiction with a well-functioning court system, which will provide adequate access to civil justice in relation to any legal dispute that could arise in relation to the registry. It's important to note that at this stage 1, tenderers must also submit Form 5 of Appendix A, indicating their compliance to the key contract provisions of this RFP. As noted before, the tenderers must agree to all mandatory contract provisions in order to move forward. Phase 2 is the technical proposal evaluation. This is subdivided into 4 different sections as illustrated by Table 1 on this slide. This will be undertaken through Forms 3 and Forms 4. Form 3 is a qualitative description of how bidders are going to fulfill all of the technical requirements, and Form 4 is a self-assessment mapped entirely onto the statement of requirements, where bidders are required to describe, where bidders are required to assess their compliance to the technical requirements of this RFP. At this stage, 10 points will be awarded for the capability and relevant experience of the bidders operating registries. 10 points will be awarded for registry operating team composition and qualification of personnel. 30 points will be awarded for the technical solution fitness for purpose, and 10 points will be awarded for the solution build and implementation team composition and qualification of personnel. At this point, I would note that the methodology for how the 30 points for the technical solution fitness for purpose will be determined based on the details mentioned in paragraph 151 of the RFP. And this methodology will be either a stratified scoring mechanism or an unstratified scoring mechanism, which will be dependent upon the number of bids received as part of this process. And this activity will be conducted by the evaluation committee. All bidders will, of course, be evaluated using the same methodology. To move on to phase 3, which is the oral presentation, tenderers must have a cumulative score of 45 out of 60. With regard to the oral presentation, at this stage, I will note that this is not an interview, but instead this is an opportunity for the tenderers to provide to describe their experience, in building this registry, the 3 possible challenges that they might face, as well as opportunities, and things such as describing how they ensure the long-term sustainability of the Mac registry, and how measures will be taken to ensure system reliability, and other items. The full list of items that tenderers will be expected to describe can be found in paragraph 154. The maximum number of points to be awarded here are 20, which are subdivided into two sections of 10, as can be seen on the slide and in paragraph 154. At this stage, I will note that if the bidders want to submit, if the bidders want to use a slide deck alongside their oral presentation, then they are invited, then they must submit this slide deck along with the rest of their application before the deadline. Any slide decks submitted after the deadline will not be allowed to be used as part of the oral presentation. All of the details of the oral presentation in terms of logistics can be found between paragraph 155 to 160. All bidders that reach a total of 55 points, at least 10 of which are obtained from the oral presentation, will then move on to the financial proposal evaluation. This is a fairly straightforward financial proposal evaluation, whereby the lowest evaluated cost will be awarded 20 points, and the rest will be awarded points correspondingly according to the simple formula listed in paragraph 163, with an example given in paragraph 164. The total number of points that a bidder may receive here are 20, as noted, and the final score for the tenderer will be the amalgamation of all three of these different points. Bidders will then, the bidders who achieve the greatest number of points will be, the bidder that achieves the greatest number of points will be invited to negotiations for a contract. The Preparatory Commission reserves the right to conduct simultaneous negotiations should it so wish to do so. And all details regarding the contract can be found between paragraph 166 to 174 of the RFP. Bidders that are not successful in their application will be notified at the stage of the awarding of the contract to the successful bidder. And all unsuccessful bidders may trigger a debriefing process as described in paragraph 175. The illustrative timeframes have been are very clearly detailed in part E of the RFP. Over here, I've inserted the actual date, which was the 21st of March for the issuance of the RFP. And as you can see, the final date for requests of clarifications is the 21st of May, with the 21st of June, the date being when we will release the clarifications. There is an optional deadline there with regard to submitting a letter of intent to submit a bid. This is not mandatory, but bidders may choose to do so if they wish. The 21st of July is the final deadline to participate in the requests for proposals. Thereafter, you can find all the details of the expected time frame that the Preparatory Commission will take to review these bids, as well as the timeline for the contract negotiations and the build for the registry. Finally, all communication should only be sent to macrfp@unitwa.org. As noted, the RFP has 6 annexes. 1 and 2 are very descriptive with regard to the additional background information of the Mac protocol and the registry. The key annex that you should definitely pay attention to is Annex 3, which relates to a statement of requirements. This is essentially what is mapped onto part 2 of the RFP, and then very greatly detailed in Form 4, which is an Excel spreadsheet. And the compliance to the technical side of this whole process is essentially compliance to the statement of requirements found in Annex 3. This annex is subdivided into a components overview, a list of functional requirements, and a list of non-functional requirements, all of which are further divided into subcategories, which I am definitely not the best person to go into detail of, but I invite you to review. As noted, Form 4 requires a self-assessment of your compliance to these requirements listed in this annex. Annex 6 is a guide on best practices for electronic collateral registries. This is something we do request that you review in making your bid and in thinking about the design and operation of the Mac International Registry. This contains 17 best practices that bidders might want to consider. Finally, I've already talked about all of these forms throughout my entire presentation, but Appendix A contains all of the forms which must be submitted separately as part of the solicitation process. Form 1 is an identification of the tenderer, fairly straightforward, where tenderers must identify themselves and any people that they will be working with as part of the submission of this bid. Form 2 is the pass-fail test, which is the tender eligibility form and contains a list of several questions that tenderers are expected to answer and will be judged accordingly in part 1 of the evaluation process. Forms 3 and 4 are with regard to the technical requirements, Form 3 being a qualitative form and Form 4 being responses against the functional and non-functional requirements, which needs to be filled as an Excel sheet. Form 5 is a contracts matrix. Form 6 is a template to insert references from other experiences that you might have had conducting activities such as this. Form 7 is a resume template. Form 8 is a declaration, and Form 9 is the expected build and operation costs, which must also be submitted as an Excel spreadsheet. At this point, I would note that Form 9 has 3 separate sheets built into it, all 3 of which are required to be filled in. But I would point out that the third of the 3 sheets is merely indicative and will not be judged per se. And with that, I will stop here. And as noted, we have about 20 minutes for questions and answers. So I would highly invite all of the participants who have kindly stayed throughout this entire presentation to submit any questions that they might have through the question and answer process or the chat feature. Thank you very much. These slides will be posted onto the webpage listed here, and a copy of this webinar will also be available on the UniDroit YouTube channel. I will now stop the screen share. Thank you. We would greatly welcome any questions through the chat feature or the question answer feature. And I would invite my Secretary General and my Deputy Secretary General to cover anything that I might have missed in this process. Thank you.
There is a question, Hamza. There is a question in the question and answers box.
Thank you very much for that question. And as far as my limited understanding goes, that would be a technical question, which we will forward to the clarifications process, and we will provide details during the clarification process accordingly. Any other administrative questions? Okay, I see a few questions in the chat section. Let me quickly read them. So yes, thank you very much for these questions, Thomas. With regard to bid security, if I understand it correctly, you are referencing submissions that you send to the UniDroit Secretariat. Yes, all submissions to the UniDroit Secretariat will be kept completely confidential and will only be opened and reviewed by the evaluation committee as established by the Preparatory Commission. This evaluation committee will be acting in accordance with strict rules that have been defined by the Preparatory Commission, including provisions relating to a declaration of confidentiality, as well as a declaration of no conflicts of interest. With regard to the second question, with regard to registry management in one country and the technical partner being in another country, as far as my understanding goes, the RFP does not provide any restrictions in this regard, as long as all of the information is clearly detailed as part of the bid. But I will still take this back to the clarifications process in case anyone has any further information to highlight here. Thank you. Excellent. So noting no, I would leave it to my Secretary General to decide if we will wait for the next 5 minutes, or should we just invite the other questions through the clarification process?
Well, let's wait a minute and see if anyone has any other administrative question. Otherwise, please do send the technical questions and we'll pass them on to the appropriate body for the decision and answer. But if there's no additional question in a minute, I think we can close the event. Okay, there seems to be no additional inquiries. So I think it only remains for us to thank you all very much for your participation. Please do not hesitate to contact us with any questions you might have, which we will address to the extent and how we can. Thank you to Hamza and to Professor Veneziano for their excellent presentations. Thank you to Hamza especially for the difficult job of having to summarize in a brief time. It might have seemed long, but it was very brief considering the amount of information that was shared. Nothing else from my side. Anything to add? Okay. Well, no more questions then. Thank you very much. And we close it here. Thank you.
Thank you very much. Goodbye, everyone.